we are going to jump to data management, as this is basically, I think, the biggest change in medical device regulations when we talk about AI-driven functions, because this is somewhat new for manufacturers who haven't not had AI-driven functions in their devices before. So I will be targeting Jovan here for many questions. And this is, of course, to kind of relate also to DeepSeek. So everybody knows what is happening in this case, that everybody now is talking about the data protection around DeepSeek. And of course, there is a lot of innovations in the AI models, but something that I think Jovan can tell us a little bit more about is this recent queries about data privacy. What type of data is collected? How is it processed? Why is it processed by DeepSeek? And what is the purpose of it? And basically, FDA is doing the same. It's trying to gather a lot of information from the AI-enabled medical device developers to understand if the quality of the data has been good that has been used for training the AI model. So, Jovan, can you tell us a little bit about the entire? I mean, we don't need to talk about DeepSeek only, and you can take this subject as broad as you wish. But what types of data can be used? How do you protect that data? How do you make it secure and throughout the entire kind of AI-enabled device development? Like, what should we do, Jovan?
Yeah, it's a topic for the whole evening probably, but I will try to squeeze it and keep it simple. So there is one main problem with, one main thing that DeepSeek or OpenAI did that medical device companies cannot do, and which is basically scrapping all the public data and stealing the data from each other, because now OpenAI is accusing this DeepSeek of stealing their outputs and distilling them and using them. So that thing that they are doing, medical device companies cannot simply afford it, cannot simply do it, because they cannot access legally to such type of data that they need. Why? Because large language models, these DeepSeek and OpenAI, they access web data on the web freely available, but they are violating laws. And there are many lawsuits now. For example, the last one I was reading yesterday about is Italian Data Protection Authority suing or raising the question, and there are many companies suing now and authors suing OpenAI because it stole the data, even though publicly available, it's not for free. So there are copyright issues there. So when it comes to if we go down deeper into medical device space and digital health space in general, that's doesn't matter. We are always talking about sensitive data, health-related data. And so the first question that companies, startups need to ask is, okay, what is really my business model? Am I B2B or B2C? Because if I'm B2B in US, I'm under HIPAA 99% of the cases, because I'm a provider to covered entities or to other business associates. As a provider, I'm called business associate. So I'm in a chain where I'm part of this game where I need to follow rules set by somebody else. So all the data that I get, they need to follow certain requirements that I can define with my partners there. So the rules are defined by the law and by the contract agreement that you have with your customers. The same applies also in Europe if you are B2B. GDPR applies to a certain extent, because at the end, what matters is your agreement with your customer, what your customer allows you to get to do with the data. Then if you're B2C, in US, it's a bit more complicated because there is no HIPAA. So there is FDA, there is FTC, there are national privacy laws, but you need to check all of them. It's a bit more Wild West also to a certain extent, because, for example, California Privacy Act hits only very large companies. So those below, the question is what you can do, what you should do, and so on. In Europe, GDPR applies whether it's your B2B or B2C, the same concepts. The main challenge in getting the data is having the rights, the legal basis, the so-called legal basis in Europe, or the rights or the basis in US. And here there is the whole topic about anonymizing data, for example. All companies, whether in B2B scenario, let's consider the B2B scenario in Europe and US, they all would like to access to the full data to train their algorithms. Full data means pseudonymized data. Companies don't want names and surnames of patients to train algorithms. They would like to access only to data, full data, but without identifiers. And here, the main difference between European and US market, HIPAA versus GDPR, where in HIPAA, by removing specific identifiers, the list of specific identifiers, you get a subset of data that is very high quality, typically, very detailed. You don't need to merge, to elaborate, to process the data in order to reuse it. This is called identified. It's equivalent to European pseudonymized to a certain extent, but in US, you have the full freedom for using this data as it was anonymous. It's not anonymous, but as it was anonymous. So you have full freedom to use it to develop your product and to elaborate, to keep it, to process it. While in Europe, pseudonymous data is still personal data. So there is still obligations under GDPR. You're still under the umbrella of GDPR. So you still need to follow a lot of rules and the contract with your customers. That's the most important thing, because in Europe, they will oblige you to keep it, to delete it, to apply data retention policies, data security, and so on, to follow still the contract. While in US, you are basically out of this legal framework and you're much more free to do whatever is necessary for your business and algorithms and development of the product. So it's really, at the end, the key question is which market you are playing, what are the requirements set by different data protection laws, and how you can avoid certain laws. And then there are so many other things to consider. For example, in order to get the data, you could also search, you can buy data from biobanks. It's a very hot topic nowadays. So biobanks, or you could start research activities with hospitals, but that's a quite costly thing. So for example, in Europe, we have a lot of European funded activities and projects where companies collaborate with hospitals, but somebody else pays the huge expenses. So there are many other considerations to make on how to get the data, how to approach this thing. But the most important starting point is, okay, what is really the legal framework you are in order to get access to the data?